Hi, I'm Asia Mallory. I'm the Senior Staff Attorney at the Maryland Volunteer Lawyer Service. And this Facebook Live, I'll be talking about the foreclosure process here in Maryland. So when a homeowner is in default, um, they will typically start the foreclosure process and here will default on their mortgage. So what is considered default on a mortgage payment is if you are 1 day late. You are technically in default of your mortgage, but you don't have to expect a notice of intent to foreclose from your lender unless you are at least 90 days in default. So 90 days is about 3 months is when you can expect a notice of intent to foreclose from your lender. Um, Once you receive the notice of intent to foreclose, that is when you should begin seeking assistance for your foreclosure prevention or your options regarding foreclosure prevention. After you receive the notice of intent to foreclose, it's typically within um, 45 days or more. After 45 days or more after the notice of intent to foreclose, you should receive an order to docket. An order to docket is a large packet of documents that include a loss mitigation affidavit, whether it's preliminary or the final loss mitigation affidavit that you as the homeowner need to complete and return to your lender. In this order to docket, there will also be a request for mediation. Mediation is optional, but uh, it is your choice to do foreclosure mediation. Mediation is helpful in the process of foreclosure prevention. Um, Once you receive that order to docket, you need to return that request for mediation. It is within 25 days of receiving the order to docket. And then you need to return either the preliminary loss mitigation affidavit or the final loss mitigation affidavit back to your lender as soon as possible so that the lender can review your information and give you any options that they may have for you. So if you do turn in the mediation request, uh, the Office of Administrative Hearings, OAH, will schedule a mediation hearing for you. Uh, if if you do request the mediation, um, usually the mediation is within 60 days of receiving the request, or uh, depending on how their schedule is going. But you can expect 60 days, and then they can extend the time to up to 30 days if there is a good cause or if the parties agree that they need a longer time before they go to the mediation date. The OAH will send the homeowner a scheduling notice with instructions for necessary documents to provide to OAH and to the lender. Documents must be provided to the OAH 20 days before mediation or before your mediation date. If you choose not to do mediation, um, your foreclosure process will skip the entire mediation uh, component of it. And so if you do that and the lender hasn't, and you're still trying to work with your lender to see what your foreclosure prevention options are or your non-retention options are, if you were given the order to docket, the OTD, with the final loss mitigation affidavit, the foreclosure sale can be scheduled 45 days after you were served with the order to docket. And then if you were given the preliminary um, final loss mitigation affidavit with your order to docket, um, there is a they have you've additionally added more time to your foreclosure timeline because they have to wait 28 days before they send you the final loss mitigation affidavit, and then once they get the final loss mitigation affidavit, there's again more time they have to wait before actually scheduling the foreclosure sale date. So if you get a foreclosure sale date, um, the foreclosure sale date is the date in which your home is going to auction. You have the ability to come to an agreement with your lender up until the day before the sale date. Um, when the foreclosure sale date occurs, you will then have essentially give or take 30 or so days after the foreclosure sale date to receive additional notices about like the ratification of the sale, the auditor's report, um, if there was an entry of deficiency judgment. All of these documents will come to you within 30 days after the sale date. But when the sale date occurs, that is like the best time to start seeking um, alternative housing, especially if you and the lender did not come to terms on either you saving the house or you giving the house off in their non-retention options. So you have about like 30 or so days after the foreclosure sale date before the lender or the purchaser motions for an entry of judgment awarding possession, which is essentially eviction. The court must issue an order granting possession. After the entry of judgment, the purchaser has to send an eviction notice. Um, Once the eviction notice is served, they have to file a writ of possession. And then once that writ of possession has been filed with the court, then the sheriff then executes the writ and evicts the homeowner or the former homeowner. So when you get that notice of a potential eviction date, that is the day in which the sheriff is supposed to come and essentially evict you out of the home. So you want to have all of your valuable stuff out of the home prior to the eviction date, because unless you and the homeowner or the lender have come to an agreement about like helping you move or having an extension, anything left in that home when the sheriff comes is now the belongs to the homeowner or to the bank or whoever bought the house in the auction. So that is just like a condensed version of the foreclosure timeline here in Maryland. Um, if you have any more questions about the foreclosure process here in Maryland, you can always contact MVLS by calling our intake line or applying online at our website at mvlslaw.org. All right, thank you for coming to my Facebook Live and have a good day.